The third week of the deadly Waukesha Christmas parade trial, in which defendant Darrell Brooks stands accused of driving an SUV through a Wisconsin parade, ending in fireworks on Friday.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name. How would you characterize it as a hit and run crash if you never investigate what you heard?
Well, because I heard a crash and then the driver ran.
Would it be fair to say that the alleged defendant that you just identified on the record for the court does not have hair?
You have shaved your head, yes.
He is threatening to throw and break items.
Does it look like I'm 160 pounds?
Objection.
Grounds?
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Brooks is charged with killing 6 people and injuring dozens more in that tragedy. He has made the choice to represent himself in the courtroom. Criminal defense attorney Brian Claypole joins me now live to help us break down what has thus far been a fairly bizarre trial. Thanks so much for being here. Brooks had previously pleaded not guilty by reason of insanity. Then he pulled that defense, ultimately deciding to represent himself at trial. He shouts, he cries, he's conducting cross-examinations himself. Is he putting on a show? Is he making a mockery of his own trial?
Hey, Molly, great to be with you. Yeah, this is an absolute disaster for Brooks. He's basically a narcissist. He realizes he's going to go to jail. So what he's doing is upstaging the trial. He's making it about him as opposed to the families, the horrible families who lost loved ones. And he made a colossal mistake, Molly. He shouldn't have argued insanity. If I was representing him, he had 2 major defenses. One was what's called diminished capacity. It's in Wisconsin. It's in most states, which means you have some type of mental illness that defeats the intent. So it drops it down to a second-degree murder. You didn't have the intent to kill. It's your mental health that got in the way. And the second one, if he had competent legal representation, is called heat of passion. He was in an argument with his ex-girlfriend just before this happened, and shortly after that, he runs through a crowd of people. He could have made that argument as well, but he didn't, and he's headed for jail.
Yeah, you know, among those killed, an 8-year-old boy, several grandmothers that have been marching in a dance troupe together. Several of the witnesses that have been called this far have given very emotional accounts of what they witnessed, what they experienced. Brooks has been cross-examining them. You know, he's not the first defendant to do this. Ted Bundy, very notably, represented himself, grilling some of his surviving victims. But how could this play before a jury and a judge?
Yeah, this is playing awful in front of a jury and judge. I mean, at one point you showed some of the clips. He gets angry, boisterous, even threatened to throw something. For a moment, I thought Jerry Springer was going to come in and be the judge one of these days. I mean, it's that bad with him. And I'll tell you, Molly, being a criminal defense lawyer, if you've got a client charged with these heinous crimes, you don't want them talking. You want them sitting there, right, and becoming more of a mystery to the jury to try to evoke some type of sympathy. Conversely, when he stands up, he's threatening people. He went on a 50-minute rage the other day, right? So the jury's sitting there thinking, this guy is nuts. We don't have any sympathy for him. And he's completely ineffective as well. His alleged opening statement was just absolutely pathetic. I mean, at one point, Molly, he said, I'm not going to argue the facts. Well, that's the whole case. That's the point of a trial, to argue the facts. So he has no facts in his favor.
Yeah. You know, the judge does appear to be giving him quite a bit of leeway in the courtroom, despite, you know, these antics that you were mentioning, the pre-trial that saw him actually removed from the room at one point. Prosecutors have also noted that the judge is being, you know, fairly lenient. Take a listen to this. This is part of the exchanges we've seen in the courtroom.
Your belief that that's the law doesn't make it so, Mr. Brooks.
I don't like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down.
This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor. And we appreciate that. He is not in control of this courtroom. You are.
frustration being expressed there, but is there concern about a potential mistrial here?
Yeah, great point, Molly. Just so your viewers know, all defendants are entitled constitutionally to effective legal representation. It is dramatic when a defendant says, no, I'm going to pass on a lawyer, I'm going to defend myself. Why? Because that elevates the chances of an appeal. So this judge, I think she's doing an incredible job. The reason why she's giving Brooks so much leeway is because if she doesn't, then an appeal is going to be filed. He'll say, hey, I didn't have a lawyer. I should have had more time to talk about this. The judge was biased. So she has to do everything possible to avoid a mistrial or an appeal on this case. But I got to tell you, Molly, in the real world, if that was me or another lawyer talking to a judge like that, we probably would have been tossed in jail.
Yeah, and so much sympathy for these victims that still have days of this trial ahead of them. Brian, thank you so much for joining us. Brian Claypool, for your insights on this Saturday afternoon. We appreciate it. Griff?
You bet. Thanks.